just so that your lordship can possibly make a note, my application under 319 was allowed in session case number 289 of
Your application or application implementing you?
sorry, not my, the application impeding me as an
You had filed an application, we will straight away dismiss your case.
Correct. So that application was allowed in session case number 289 of 2015.
That was not pending on that date.
Correct. The case against that one absconding accused, the charge sheet against him is filed on 3rd September 2019. And that case is now session case number 217 of 2019. My application, if at all I lose everywhere, has now to proceed in session case of 15, which today is no longer pending. So therefore, that is the factual position where things stand. Now, my lord, I think I should take your lordship to Hardeep Singh straight away. But before that, just one provision I want to point out, I could not point out. Just kindly have section 437, subsection 7. There are other also which give stages where a particular thing can be done under the criminal procedure code. I will by tomorrow put them on a single piece of paper and then hand them over to your lordships. But just see, relevant to the point here, 437 subsection 7. If at any time, after the conclusion of trial of a person accused of a non-bailable offence, and before judgment is delivered, the court is of the opinion that there are reasonable grounds for believing that the accused is not guilty of any such offence, it shall release the accused if he is in custody on execution by him of a bond without show. So after conclusion of trial, but before judgment is delivered. So the court makes a distinction as to when the trial concludes. And actually Hardeep Singh saying that before pronouncement of judgment really has to be read to me till conclusion of trial, because now just kindly see here itself 319. 319, the section is very clear. And therefore, my lord, it cannot be stretched to any other interpretation. 319 says,
You already read.
yes, it says that in the course of any inquiry into or trial of another. That's the stage. Now, there are one or two reasons which it's very important that this should happen when the trial is pending. First is that question of charge sheet being filed or not. Because if the trial is pending, there is no requirement of a supplementary charge sheet. Because in other judgments, where the question was whether a person who is arraigned as an accused under 319 can apply for discharge or not, your lordships have held he cannot apply for discharge. Because he is a different kind of accused who has been actually made an accused on the basis of evidence by the court itself, and therefore there is no question of the provision of discharge applying to him. So therefore there is similarly, then the charge would probably procedurally, we were discussing, procedurally then the charge would be amended to include him in the charge, because then the court has already charged him and said that you are also, I feel you are also guilty of this offence. So the charge would be amended and the trial would proceed. And therefore he is entitled to cross-examine those witnesses. Then that cross-examination which he does, that evidence will be utilized for the benefit of or to the detriment of all accused. So therefore, my lord, it's very important that technically now, arguing against myself, today also there is a trial pending 217 of 19. On the basis of evidence in that trial, again the state may have a right to make an application, which is a separate issue altogether. But the question is that where a trial has concluded. Now, my lord, two orders I want your lordships to see before I go to Hardeep Singh straight away. First, I want your lordships to see the relevant part of the order passed under 319 in my case. And then, my lord, there is one order which the other side realized that 319 had been separated from the main trial. I'll read that order also to your lordships. The order, my lord, in the 319 application is at page 121 of the paper, volume 1. extra period. To the extent that it is relevant for the submissions which are being made before your lordships in the constitution bench, it is at page 130. That's all. On merits, it may not be relevant. When I argue merits, I will show the merits there. But kindly have page 130. As
Stand out.
correct. As things stand out, this FIR number 35 was registered and challan against 10 accused was presented by mentioning that after investigating the challan against the remaining accused will also be filed. But till date, no challan is presented against accused whose names are mentioned in the application under 319 CRPC. By my separate judgment,
all accused against whom challan was presented, except one, are convicted today. So this is being done after that judgment is passed. Whether it is done on the same day or after 10 days, the legal consequence, in my respectful opinion, will be the same. So the learned judge is recorded, by my separate judgment, all accused against whom the challan was presented, except one, are convicted today. The proceeding of this application was separated from the main challan because the High Court in the main challan had directed this court to decide the case up to 8th November 2017, then call detail, etc., etc. Then at the bottom of the page, he says, the learned judge says, as discussed above, I am satisfied there is every likelihood that accused Sukhpal Singh, Khera, Joga Singh, etc. are likely to be convicted if allegations are not rebutted. Further, while filing the challan, it was mentioned that after completing the investigation, challan against these accused will be filed. Same is not filed by the
police. To my mind, accused accused is ongoing pending, having been bifurcated from the main trial. This is a completely different fact situation. It does not exist in my case at all.
Now, and the answer to this question would depend on the facts under which this question is arising. If a trial is actually bifurcated and for some accused you pass judgment, then that trial is still pending for the other accused. And then, of course, 319 can be there. But that's a fact situation.
Subsection 1 once again, right?
Yes, Manoj. Yes, yes.
319, once again we'll read carefully.
Yes,
Let us read 319.
yes,
Please read, then we will go to Hardeep Singh.
yes.
Yes. Where? Read in.
Where
Ah.
In the course of any inquiry into or trial of an offense, it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together with the accused.
So we will stop for a minute. Therefore, in the course of enquiry or trial, if something comes against a certain person for a, now at what stage can it be done? Next sentence you read. At what stage?
The court may proceed against such, so the stage is not mentioned. At what stage the section doesn't say.
No, stage is in the opening lines. In the course of any inquiry or trial.
That is in the course of the inquiry or trial an offense, it appears from the evidence that may.
It will have to be read for the entire
No, that is,
sentence.
no.
No, it is.
Where I understand what the way your lordship is reading it is bifurcating it. That evidence can be earlier and order can be later. Not, I don't. I would respectfully submit that the course of inquiry or trial it will have to be read with the entire provision.
Because it has to be tried together.
Correct. Correct. Correct.
Such person could be tried together with the accused.
Correct.
Oh, yes, yes.
The court may proceed. Now, in a judgment, your lordship said that this second part is directory. I don't agree with that judgment, Lord.
In my respectful submission, that is also a matter for your lordships to see. Because then that is that Shrikant. In Shrikant, the order had been passed during the when the trial was pending. So now kindly have 319.
So the language applied is such person could be tried together.
Correct.
Therefore, once the judgment is pronounced, how can you try together?
Correct. Absolutely. But absolutely. So, but then also read 3194.
Well, 3194 is de novo trial. 3194 is the procedure.
I'm reading
All right,
it.
let us
I'm
see, let us
reading it. You will have your turn to read it.
Already.
When the-
Shrikant has
when-
clarified it.
Where the court proceeds,
where the court proceeds against any person under subsection 1, then the proceeding in respect of such person shall be commenced afresh and witnesses reheard. Subject to the provisions of clause A, the case may proceed as if such person has been an accused when the court took cognizance of the offense upon which the inquiry or trial was commenced. Now kindly read 4B. If that trial is concluded and Shrikant is right in what it says, that it is directory, how are we going to reconcile this 4B with the first part?
Shashikant.
Sorry, Shashikant. Shashikant, sorry. So how are we going to reconcile clause B? It's not, we are now before 5 honorable judges. And I feel that it is directory is not a correct view. It's not, because then you are completely doing, rendering OTOs. The opening part of 3191, it has to be the same trial.
but then how do you reconcile 4A, subsection 4A? The
Yeah.
proceedings in respect of such person shall be commenced.
Afresh,
and
because
witness
all
heard.
witnesses.
How do you reconcile
Yes.
this?
So all witnesses who have been examined in his absence before he is arraigned under 319 will have to be reheard, because naturally they will have to be recalled so that he can cross. Their chief may remain the same, but his lawyer will be entitled to cross them. So therefore, for cross-examination, they will have to be recalled. And the case, however it is clarified in B,
Proceedings in respect of such person shall be commenced afresh.
correct. And witnesses
Reheard.
reheard.
So how do you say that it's only for the purpose of cross?
No, for all, your lordship is right. It will be as if fresh. But then read B. It's a scheme. Correct. Now read B also. Subject to the provisions of clause A, the case may proceed as if such a person has been an accused when the court took cognizance of the offence upon which the inquiry or trial was commenced. Now, this necessarily presupposes a live inquiry or trial. It does not include an inquiry or trial which has already been concluded. That interpretation is very, it does not promote the cause of justice. Now, one trial is concluded. Let us take this case. Those witnesses, that is pending in the first appeal. In the same session case, I will be retried. Same witness will come. What if he gives the different evidence which is supporting the accused? How is those accused going to then? It will create a situation which is anomalous.
Actually, he becomes an accused
It will cause
retrospectively from the date of
Absolutely.
taken cognizance.
But my point is, my lord, that B therefore provides inbuilt a live inquiry or trial. And this court saying this is only directory and not mandatory is not correct. Now, just read 319, the opening part, where in the it actually doesn't directly arise here, but this is my respectful submission. Where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not accused has committed any offence for which such person could be tried together with the accused. The court may proceed against such person. So it is only if that person could be tried together with the accused that the court has to proceed against him.
Because the evidence must be recorded in the presence of the
One question to you. It may be difficult to answer, perhaps. Supposing a 319 application is filed in that accused case, what happens? Supposing.
On the basis
We
of,
know in every case there won't be a absconding accused, but in this case particularly,
if it is
what
filed,
would have happened?
if it, on the basis of the evidence there, I could have been summoned. If the court felt I had committed no offense.
So there
There
the
is-
trial is fine.
I cannot run away from that. That's the law. Then I will have to get that order tested that the evidence is not good enough because Hardeep Singh comments on that. But this argument is not available to me.
No.
Because that is a pending trial. And I can be summoned there. There is no doubt about it.
No, why?
Trial, he comments only if he is arrested. And he's,
Now it's all-
No, they have now filed a charge sheet.
No.
They have filed a-
Is he absconding or has he arrested?
he's still absconding?
He's facing trial. He's arrested and facing trial.
This contention of saying that the application cannot be filed after the trial would not have been available there.
Correct.
But still the validity of the application and the summoning order could have been essayed.
Because Hardeep says 319 is not an ordinary provision.
Correct.
If you are almost sure he's going to be convicted on the basis of what is before you, then call. Otherwise, don't call. That's the
Mr.
quality
Puri,
of evidence which Hardeep says. is
Hardeep
required.
doesn't say in unequivocal words that once the judgment is delivered, the application cannot be granted. So if you see the answer at page 141,
Correct.
they only say that it can be considered at the stage of trial.
Correct.
Para 117.2.
No, that is said earlier, my lord. Those paras are earlier. I'll show your lordship. And I'll read that what your lordship is saying, my lord. Then show your lordship the relevant part. Your lordship is
Page 141,
141. Yes.
paragraph 117.2.
Three one nine. By section 319. Material coming before the court in course of such inquiry can be used for corroboration of the evidence recorded in the court after the trial commences for exercise of power under 319 and also add an accused whose name has been shown under 2. In view of the word, the evidence has to be broadly understood. But this is regarding the evidence which they are answering.
No.
No.
Both questions.
Yes,
To answer one question, 1 and 3, they answer it
correct,
together.
correct.
Answer is that.
At para 38, but conclusion is para 47. This is the para 47, the top of, but it starts from para 38. I'll read it. But anyway, 47, if your lordship will see. 40 also. From 38 onwards, I will have to read, my lord, but I'm just reading this one line and then I'll go back to it. Since after the filing of the charge sheet, the court reaches the stage of inquiry, and as soon as the court frames the charges, the trial commences. Therefore, the power under 3191 can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during sections 207, 208 committal incident. This is the crucial part. So, and it's this is the discussion leads to it.
Mr. Patwalia,
Yes.
now here luckily or unluckily, one of them absconded and there is a separate trial. So, even according to, they could have filed this 319 application in that. And in a case where there is no, there are no absconding witnesses, then they will lose the right forever.
Correct. They will not, because that's the stage. That's
So you must see that somebody is absconding.
no, not that. Not his
No,
absconding.
no,
The state-
we are telling you a peculiar situation, how to wriggle out of this.
No,
Second question, sir.
Huh?
Second question is about absconding. First question is without absconding.
Not
Both questions
actually-
are referred. Both questions are referred.
No, Hardeep Singh case, there is no absconding business.
No.
There is no absconding.
Actually, not 319 application is not even necessary. The power is conferred on the court on the principle that a guilty may escape, innocent may, but no person who has committed the crime should be allowed to get away. Now, this power is on the court. Now, here the state is nudging the court But just see 319 doesn't need an
No,
application.
no, they are not nudging the court, they are assisting the court. Put it in a.
So, yes. Huh? Their power is to charge me under 173. My learned friend is right. Their power after investigation, if they find something against me, is to charge me under 173. And they can file a charge sheet, a supplementary charge sheet, another charge sheet. Here they have come under 319. I mean, they could have, I was, use the power under 173 if available. But here the 319 is actually not a power for an application to be filed. 319 is actually a power which is with the court. If your lordship may kindly now read it with this background with me. Where in the course of any inquiry or trial of an offence, it appears from the evidence that any person not being accused has committed any offence for which person could be tried together with the accused, the court may proceed against such person. So therefore, the court will only be able to produce if there is some live trial pending before it. So necessarily it has to be after the charge sheet is filed, when the inquiry commences, and before the trial is concluded. That's the only time when the court can proceed.
That's why the word course is used.
Correct.
Course.
Once your lordship is interpreting it,
In the course.
correct. Hardeep Singh, my lord, according to me, takes into account everything and takes into account all.
Hardeep Singh, it does not clearly hold so, because even if you again turn to para 57.
Para 47.
57.
57. Thus, the application of the provision under section 319 at the stage of inquiry is to be understood in its correct perspective. Power under 319 can be exercised only on the basis of evidence adduced before the court during trial. So far as application during the course of inquiry is concerned, it remains limited to, as referred herein above, adding a person as an accused whose name has been mentioned in column 2 of the charge sheet, or any other person who might be an accomplice. Because there the court says during inquiry, court doesn't have any independent evidence. So only if a person is an accomplice or under column 2, court can shift him. But may I just read it from the stage where they start considering it? Lordship may just have. I'm just going to be.
Alright, you read.
I'm just going to be rather quick where it's not needed, but some paras I will have to read.
Alright, take us through the.
Yes, yes.
Right.
So, my lord, the questions I had read, I don't need to read again at para 6, I had read it.
Yeah.
Now, 7 is in this reference, what we are primarily concerned with is the stage at which such powers can be invoked. Now, that's one. In this reference, what we are primarily concerned with is the stage at which such powers can be invoked. And secondly, the material on the basis of whereof invoking powers can be justified. Second is not at large before your lordships. To add as a corollary to the same, third is the manner in which such power has to be exercised, also has to be considered. Then, my lord, articles 20-21 are considered in para 8. Para 9, my lord, I'll read the opening words. The presumption of innocence is the general law of the land, as every man is presumed to be innocent unless proven guilty. Alternatively, certain statutory presumptions in relation to certain classes of offences have been raised against the accused, whereby the accused presumption of guilt prevails till the accused discharges his burden, etc. My lord. Then, para 10, section 351 is referred to. Then, how cognizance is taken, that is considered, my lord. Then, on the next page, 114, 319 is mentioned. Then, my lord, para 12, I want to read. Section 319 brings out the doctrine of judex daemonor cum nosis absolvitur. Judge is condemned when guilty is acquitted.
Be anything else. Therefore, I, as the petitioner, have not asked for reconsideration of Narasimha Rao, and I'm only pleading that the High Court has erred in wrongly applying Narasimha Rao against me when Narasimha Rao ought to be applied in my favor. There's no question of questioning the correctness of Narasimha Rao. In which case, if the first order of reference only talked of wide ramifications, and the second order of reference talks of public importance, wide ramifications, and the doubts expressed, who with respect has expressed those doubts. The doubts on paper are only the doubts of the two learned dissenting judges. Powerful reasoning, no doubt. But that is the only doubt on record which could have weighed in the minds of this three-judge bench. It would have been a different matter if this three-judge bench had on its own held and recorded that paras so and so, so and so, so and so of the majority judgment of Narasimha Rao appear to us to be doubtful in the light of so and so, so and so, and we feel Narasimha Rao may require a fresh look. That would have been sufficient reason. If a seed of doubt is sown in the minds of the bench, either by a party or the bench of its own accord, entertains the doubt and articulates the doubt, then it follows, Millards, that the process of reference must be carried further through, as per judicial discipline, first to 5 judges, and then 5 judges feel, then 5 to 7. But in the absence of such a judicially expressed doubt, in my respectful submission, there is no need for reconsideration of Narasimha Rao.
But Mr. Raju, one question or one doubt, our doubt.
Lordship, please.
Now, the court has expressed doubt on the majority view, right? By 3 judge bench. 1 minute, one by one. Now, neither Tushar Mehta nor you dispute the correctness of the majority view.
Lordship, please.
Now, but the court has raised doubt. Somebody should assist us on the other side also. There is none here.
If you're not for this,
Only a minute.
or sir, just 1 second, let me just complete this. If your lordship's brilliant opponent read this sentence, and since one of the learned judges on the bench is before this in this bench also, that this itself means the doubts expressed refers to the doubts of the 3-judge bench and not the doubts expressed in the minority in Narasimha Rao, then of course, Millards, the doubts expressed by the 3-judge bench must be adequately addressed.
One more reason, Dr. Ramachandran, actually, there is a case of payment of money. Suppose there is a case members of legislature.
If it is held captive, if the family members,
It is not protected. Not may I say.
that's
May I
not the
say,
fact,
now if
that's
you,
not the fact situation.
the substantially,
Mr. Solicitor and Mr. Ramachandran, now in any case, the bench of 3 learned judges, we don't know what was in the mind.
Correct. What is referred?
and also I want to add, I am also a party to that.
Yes. Lord, if my learned friend allows me, he has substantially diluted his case, my lord. Let me, my lord, further.
And if you allow us.
I'm so sorry. I am so sorry.
3 judges bench has raised some doubts with regard to correctness of Narasimha. So we have to honor the,
Certain. I bow down. The question would be,
both of you are one side.
no, we'll assist you
Both of
on this issue.
on this issue.
Yes, we'll
Unfortunately, both of you say that Narasimha Rao has been.
No, he tried his best, my lord, to dilute his case, but I still, my lord,
He also doesn't. He also doesn't.
but I am saying something slightly different.
Therefore, when a bench of 3 honorable judges
I bow down, my lord. No further discussion on that.
We must have some view of as to whether it is correctly decided or not from an independent.
My lord, let us now, my lord, go a step further. I bow down, my lord. Once there is a reference, it needs to be answered, because that's how, my lord, the system works, that's how the discipline works. The question would be, would a bench of coordinate jurisdiction of 5 honorable judges be able to say either way that it does not?
We can say that if we are convinced that Narasimha Rao has been correctly decided, then we can close the matter, and if we find that it is not correctly decided, then only the question of
Reference may.
But please. Then may I take my notes?
If we also have a doubt, then it has to go to sir.
Yes. That's all.
Now therefore, now the task.
Ultimately, it is
Logically.
what is the extent of that immunity
Logically.
for what acts done by a member of parliament or for a member of the legislative assembly.
On the floor of the Kerala Legislative Assembly,
Yes.
by later, the public prosecutor sought to withdraw that prosecution on the ground of immunity. That withdrawal was not allowed. Not allowed.
Sorry.
Yes,
All right,
I'm
Mr.
sorry,
Raju,
I'm answering.
Mr. Raju Ramchandra, please listen to us. See, we want assistance.
Logically.
Yes, yes, we'll assist.
Ms. Patwalia, why don't you assist the court here?
Yes.
Please, where is Gaurav Agarwal? He is here. Where is Gaurav?
But Mr. Gaurav Agarwal is really busy as an MICA, so he will not be able
To
to.
assist Patwalia.
Yes,
You please, Patwalia.
Surely.
And Patwalia, please assist us, right?
We will do that.
Because require the other words you have heard, yeah.
Settle. Well, we will also assist them.
Yes,
That's not the question.
If we concur with Narasimha Rao, then further
Yes,
would
yes.
not be necessary.
Absolutely,
We
absolutely.
can send back the matter to the learned 3 judges or 2 judges for deciding it on merits.
Yes.
Correct.
On merits, I am opposing it. Madam.
Yes.
On proposition of.
We can't go into the question
Yeah,
of merits.
that's fine.
That has
On
to be
proposition
considered.
of the constitutional principle, I feel my lord Narasimha Rao is rightly decided.
That is what Raju says, so no opposition to it.
Raju unfortunately did not say, my lord. He said many things and we went into a.
No, he
That's not fair.
That doesn't matter.
He categorically said that he is protected by Narasimha, but the learned single judge has wrongly applied under.
As a matter of fact, my lord, my lord, sometimes if we write a novel instead of my lord, a para, it is my lord, less effective. In a case of Kerala, which he was my lord, addressing, in Kerala there were hooliganism in the house, and the court said that they are not protected under 195. That was the one line which was.
This is vandalism instead of hooliganism.
Yes, but it was a novel. I am giving a paragraph.
We will do that. Come, right. Come. See. Yes, but the council is requested to assist the court as an amicus curiae. She full name Gaurav Agarwal. Any initials? No.
No, he writes Gaurav Agarwal.
Gaurav
Writes Gaurav Agarwal.
He is really Gaurav.
Gaurav Agarwal, Learned Council, Learned AOR, right? AOR is requested to assist Mr. Patwalia in this case. List this case when? January, right? After 7th.
No, December. I would request for December. I would earnestly request.
Because
For
I was a party.
that doesn't matter. No, that how does that matter? How does that?
See, I was telling my brother, just now I told him, so far I am the Karta of this bench. I will pass on the Kartaship to my brother.
No, my lord. But my lord,
All of us would love to have it in December.
we are the co-partners, my lord.
We don't think that it will take more than a day.
It cannot. It cannot. Should not take, my lord. If we.
The two perspectives, the judgments and the independent perspective of the
You can
amicus.
take the
That I
paper
would
book
have to-
today itself, not start. You need not have paper book for that, strictly speaking, you just have to examine.
Whether
It's a question. I have not even opened on
And
fact.
assist to the
But
student,
I give
correctly
the,
decided or not.
I give a paper book to him. my lord.
Well, 6th is all right for you.
Any day when your lordship fixes it, so.
6th is Tuesday.
That's all right.
Tuesday is all right.
Lordship, Lordship.
List on 6th.
Any vote, any vote.
On the lighter side, your lordships only have the jurisdiction to grant an injunction. But here as a karta, the co-partners, my lord, injuncted your lordships, my lord, from,
No, but
Including the co-partners here.
no.
yes, my lord, but I can't,
Solicitor, who included you as a co-person here?
my lord, here I,
Self,
no, my lord, my lord, I was only on two of us.
see,
Would wish, my lord, I can hear, but I,
No, I was just telling my learned brother that I had some objection because by two of my learned brothers and sisters, they were conferring in some language which we both of do not understand.
Yes, Lords, that's an overwhelming majority.
that is, my lord.
all right,
I
thank
think, my lord, yes, my lord, all, the majority can confer in a different language.
you. All right, we will have it.
Great, sir.
Obliged, your lord.
Kamsa is recognizing the lady as a co-parson.
Law has parliament has recognized.
No, now yes, of course, my lord, your ladyship can be a co-partner.
And Vinita Sharma, again, I am a party.
My lords have decided.
Elder brother is party to Vinita.
Yes, yes, my lord.
But we have given a cut-off date, right?
Yes, but I was not including on your lordship, my lord. I was saying we are the co-partners.
Date, please.
Date, sir?
Right.
Date.
Is regarding interpretation of section 319 of the Code of Criminal Procedure. The
Where is Nagamuthu? You are in this case? Not in this case?
319, Nagpattu,
You assist the court, Nagamuthu, here also. Let him hear, if you want, we can, you can give a date also, but you, let us hear, Mr. Patwale, if you want, we can take it up again tomorrow. For you, this is a very small matter, 319.
you had substantially argued it before a division bench. So result is immaterial.
All right, yes.
may it please, your lord. Lord, my issue is very narrow and limited. And my issue is that the order under 319 in this case was passed after the trial in the main case was over. The order itself records that by a separate judgment, I have concluded, convicted and sentenced the accused today, and then I proceed to pass this order. Now, 319 is a power which is to be exercised during inquiry or trial as per the section itself. This has been interpreted by a 5-judge bench of this court, my lord, in Hardeep Singh's case. And therefore, according to me, it is completely covered. The reference order, I'll read to your lordships, my lord, first, and then I will take your lordships to the facts of this case and my submission.
Patwale, what is the date of the reference order?
Yes, the reference order is dated 10th of May 2019. Yes, that's right. And thereafter it comes to 5 by 5th of September. First 10th May, your lordship.
And then 6th of September. This is by, I think, learned 2 judges.
Correct. And then it went,
Thereafter, the learned 3 judges referred to a 5 judges.
yes, and then the learned.
That is 5th of September.
Correct,
2009.
correct. The learned three honorable judges said that let it be placed before 5.
Constitution bench.
Correct.
The first, this is 10th May, is it? 10th May 2019.
First order, yes, is 10th May 2019.
Yes, we
That's
have.
the order. That is really the mind of the judges.
All right.
Therefore, I'll read that.
Yes, we have.
These criminal appeals are filed against the impugned judgment and order of the High Court. of-
1 minute, my learned.
Just 1 second.
Just one.
Yes. Yeah. 20 years.
All right. Yes, we have.
My lord.
Yes.
These criminal appeals are filed against the impugned judgment and order of the High Court of Punjab and Haryana, dated 7th November 2017, passed in criminal revision number so-and-so and criminal revision number, where the High Court dismissed the criminal revision petitions and upheld the order of the trial court, summoning the accused appellants under 319 of the Code of Criminal Procedure. The factual narration of this case is that on 5th March 15, a first information report was lodged in the police station Sadar Jalalabad against 11 accused for the offence committed under sections 21, 24, 25, 27, 28, 29, 30 of the Narcotic Drugs and Psychotropic Substance Act 1985. Section 25A of the Arms Act and Section 66 of the Information Technology Act. Initially under the first charge sheet, dated 6 September 15, 10 accused were summoned and put to trial in session case number 289 of 2015. Even though a second charge sheet was filed by the police, the same did not name the accused appellant there. Subsequently, on 31st July 17, the prosecution filed an application under 311 of CRPC for recalling PW 4 and 5, which came to be allowed. On such recall, the aforesaid witnesses named the accused appellant therein. Thereafter, the prosecution filed an application under 319 of CRPC in session case number so-and-so for summoning additional 5 accused, including the present appellant, by placing reliance on statements of PW 4-5 and PW 13. On 31st October 2017, the session court first pronounced the judgment in session case number 289 of 15, convicting the 9 other accused put on trial. On the same day, by a separate order, the session court, while allowing the application of the prosecution, summoned accused appellant under 319 of the CRPC. Agreed by the summoning by the session court, the accused appellant filed separate criminal revision petitions in the High Court of Punjab and Haryana, being criminal revision numbers are given. The High Court, by common judgment, impugned judgment, dismissed the revision and upheld the summoning order. Agreed by the impugned judgment and order of the High Court, accused appellants have approached this court through these petitions. Having heard learned counsel for parties, learned senior counsel appearing on behalf of the accused appellant in SLP number contended by relying on Hardeep Singh versus State of Punjab 14(3) SCC to state that power under 3191 can be exercised at any time after the filing of the charge sheet and before the pronouncement of the judgment. In the present case, the summoning order passed after the order of conviction is in clear breach of the principles laid down in Hardeep Singh Supra. Counsel further contended that when Hardeep Singh has clearly prescribed the stage at which an application under 319 can be entertained, the aforesaid violation is not merely procedural, but rather a substantive one. Lastly, the counsel contended that the moment the trial is concluded and matter is reserved for judgment, then the stage for exercising power under 319 ends and the court becomes functus officio. Mr. Giri Learned Counsel, senior counsel appearing on behalf of the accused in the other SLP, while generally supporting Mr. Patwalia, has submitted that the order summoning the appellant was passed simultaneously with the order of conviction of other accused. The counsel submitted that section 3194 has to be read along with 3191, which provides that the new person has to be tried together with the accused. The principle is based on communality of evidence. But in the present case, allowing such application under 319 goes to the root of the fair trial, as the court has already considered such evidence and proceeded to speak on it. It is the same evidence which would be reappreciated, and the inclusion of which such evidence vitiates the principle of fair trial. Learned senior counsel appearing on behalf of the state in SLP argued that even if it is assumed that the summoning order was passed subsequent to the conviction order, the relevant consideration is that application of mind was within the prescribed time under section 319. The process of application of mind and pronouncement of summoning order are separate under 319, and it is the time of application of mind which is relevant. The court further drew attention to the fact that undisputedly the application under 319 was filed and heard during the pendency of the trial, and the order thereon was reserved. In this context, counsel submitted that application under 319 was separated from the trial by direction of the High Court. That's not factually correct, but anyway, I'm reading it the way it is recorded. In this context, the counsel submitted that application under 319 was separated from the trial by direction of the High Court so as to complete the trial expeditiously in a time-bound manner. Now the aforesaid fact cannot be used to prejudice the case of the state. Lastly, the counsel maintained that summoning order under 319 was passed on the same day, simultaneously, along with the final judgment convicting the other accused. Moreover, there is no procedural irregularity committed. Moreover, he emphasized that the trial in this case could not be said to be completed unless decision was given in respect of all the accused fully. This submission was based on the fact trial had been bifurcated and was pending in respect of the other absconding accused, which would sustain the exercise of power under section 319. Learned senior counsel appearing on behalf of the state in SLP number so-and-so, while supporting the arguments made by learned senior counsel, further submitted that it is settled law that procedural laws must be liberally construed to render justice. Moreover, assuming but not admitted that an irregularity in exercise of power under 319 was committed by the trial court, the same would not vitiate the proceeding. The counsel concluded his arguments by stating that the finding of the trial court cannot be reversed under 456, as the appellant has not made out a case of failure of justice. In the facts and arguments presented, the following question arises. Now, whether the order of the session judge summoning the appellant hearing as additional accused was in breach of 319. If the answer to the above is in the affirmative, would the order of the courts below still be sustained under the code? At the outset, it is pertinent to note that 319 reflects two important objectives. Firstly, the court's duty to bring home the guilt of all accused and render complete justice. And secondly, the duty of the state to take every criminal prosecution to its logical end. This court in a catena of judgments has defined 319 as an enabling provision, especially in the circumstances where the investigating agency has failed to array any person as an accused. This provision empowers the courts for calling such persons to face trial. The section stipulates that a court may summon any additional accused if it appears from the evidence during the course of any inquiry or trial that such an individual, not being an accused, has committed any offense for which such person could be tried together with the named accused. Subsection 4 of section 319 of the CRPC indicates that the proceedings with respect to the summoned individual, as per clause 1 of 319, may be a de novo or joint trial. The appellants have argued for a comprehensive reading of 3191, where the aspect of application of mind by the judge as well as pronouncement of the order are both bound by the prescribed time limit. They have extensively relied on Hardeep Singh to point out that trial court was functus officio and did not have the jurisdiction to deliver the order of summon. The High Court, while repelling the contention of the appellant that the trial court was functus officio when the summoning order was passed, placed reliance on the factual matrix explained later in Shashikant Singh and noted that the decision in Shashikant was on the same point rather than Hardeep Singh. In Shashikant, this court was concerned with a unique situation. The question which was before the court therein was can a person summoned in pursuance of an order passed by a court in exercise of power conferred by 319 of the Code of Criminal Procedure be tried for the offence for which he is summoned after the conclusion of the trial wherein such an order of summoning was passed is the question that falls for determination in this appeal. While answering the same, the two-judge bench in Shashikant held as follows. Provision cannot be interpreted to mean that since the trial in respect of a person who was before the court has concluded with the result that newly added person cannot be tried together with the accused who was before the court when order under 3191 was passed, the order would become ineffective and inoperative, nullifying the opinion earlier formed by the court on the basis of evidence before it that the newly added person appears to have committed the offence, resulting in an order for his being brought before the court. The mandate of law of fresh trial is mandatory, where the mandate that newly added accused can be tried together with the accused is directory. The High Court has placed extensive reliance on factual matrix of Shashikant's case to draw parallels between the similarities in both cases. The summoning order in the former case, the trial has ended, whereas in this case it was passed after the trial has ended, with after the passing of judgment in session case number so and so. Therefore, this court, while dealing with Shashikant, interpreted the law based on the facts available therein, whereas the present case has a different context altogether. In this context, it is important to note that when Hardeep Singh's case was heard by the two-judge bench, this court took note of the findings in Shashikant's case supra. The two-judge bench observed that in Shashikant, during the pendency of trial of an accused, another person was summoned by the trial court under section 319 of the code. But by the time he could be brought before the court, the trial against the accused was over. It was held by this court that the words could be tried together with the accused in section 319 were merely directory, and if the trial against the other accused is over, such a person who was subsequently added as an accused could be tried after the conclusion of the trial of the main accused. Taking note of the above two-judge bench in Hardeep Singh, referred the matter to three-judge bench on the following question. When the power under subsection 1 of section 319 of the Code of Criminal Procedure of addition of the accused can be exercised by a court, whether application under 319 of the code is not maintainable unless cross-examination of the witness is complete. What is the test and what are the guidelines of exercising power under subsection 1 of section 319 of the code? Whether such power can be exercised only if the court is satisfied that the accused summoned in all likelihood would be convicted. Subsequently, this court in the aforesaid matter of Hardeep Singh laid down the scope and extent of the powers of the court in the criminal justice system to array any person as an accused during the course of trial as per 319. The questions which were formulated by the larger bench were, what is the stage at which power under 319 of the Code of Criminal Procedure can be exercised? Whether the word evidence used in section 319 of the Code of Criminal Procedure would only mean evidence tested by cross-examination, or the court can exercise the power under the said provision, even on the basis of statement made in the examination in chief. Whether the word evidence used in 3191 of the Code of Criminal Procedure has been used in a comprehensive sense and includes evidence collected during investigation, or the word evidence is limited to evidence recorded during trial. What is the nature of satisfaction required to invoke the power under 319 of the Code of Criminal Procedure to arraign the accused? Whether the power under 3191 of the Code can be exercised only if the court is satisfied that the accused summoned will in all likelihood be convicted? Does the power under 319 extend to persons not named in the FIR or named in the FIR but not charged? We note that the difference of formulation in the reference question and the final order of the Constitution bench with respect to question 1 makes a difference with regard to the present case. It is precisely the gap between the restricted formulation of question number 1 by the Constitution bench and question number 1 in the reference order of Hardeep Singh, which these unique facts fit in. The earlier question number 1 in the reference order was broader in comparison to reformulated question by the Constitution bench. It is this marginal area which is sub silento, which needs to be referred to a larger bench. Again, in Hardeep Singh, the Constitution bench set out to answer the questions referred above. In this part, we are mostly concerned with the first question. The court, while assessing the ambit of the term trial, was concerned with the stage during which the power under 319 could be exercised. In this regard, it was held, since after the filing of the charge sheet, the court reaches the stage of inquiry, and as soon as the court files the charges, the trial commences, and therefore the power under 319 can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during the stage of section 2078 Code of Criminal Procedure, committal, etc., which is only a pre-trial stage intended to put the process into motion. This stage cannot be said to be a judicial step in the true sense, for it only requires an application of mind rather than a judicial application of mind. It was contended that the question of law here is unique to the present case, and the earlier judgment of Hardeep Singh did not have an opportunity to cast any light about the validity of the summoning orders pronounced after the passing of the judgment. They further argued that Hardeep Singh treats 309 in an isolated manner without taking into consideration the spirit and mandate of the court. To strengthen the aforesaid submission, the state further 465 was introduced to provide for a balanced mechanism under the criminal justice system to stop courts from getting into hyper-technicalities and committing serious violations. Court in Hardeep Singh has not considered the above principles or the issue that could possibly arise before the trial court while dealing with application under 319. The state therefore submitted that 319 should not be treated as an isolated island, should be given a pragmatic interpretation by keeping in view the entire mandate of the court to render complete justice. Needs to be determined whether trial is said to be fully concluded, even if the bifurcated trial in respect of absconding accused is still pending consideration. The appellant herein contended that observations made in Hardeep Singh cannot be diluted by a bench of this type. We have considered the averments made by the counsel on behalf of both the parties. We feel it would be appropriate to place the same for consideration before a larger bench. However, we are of the considered opinion that power under 319 being extraordinary in nature, the trial court should be cautious while summoning the accused to avoid complexities to ensure fair trial. We must remind ourselves that timely disposal of matters furthers the interest of justice. After perusing the relevant facts and circumstances, following substantial questions of law arise: whether the trial court has power under 319 of CRPC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of conviction rendered on the same date before pronouncing the summoning order; whether the trial court has power under 319 for summoning additional accused when the trial in respect of certain other absconding accused is ongoing pending, having been bifurcated from the main trial. What are the guidelines that the competent court must follow while exercising power under 319? Then matter should be placed before the Honorable Chief Justice. Then 5th September, the court said that it should go before.
Mr. Patwalia, therefore, once the judgment is reserved and before its pronouncement, as per Hardeep Singh, 319 can be applied. Now, that proposition is doubted in this case, right? Or what exactly is the point you want to?
The point is, after judgment is pronounced, according to me.
No, Hardeep Singh governs what situation?
Hardeep Singh says very clearly that Hardeep Singh interprets 319. The words of, let me just read 319 to your lordships first of all. Let me just read 319. Yes. According to me, my lord, my case is crystal clear, completely covered by what Hardeep Singh says, and this whole argument that application of mind time has to be seen is neither here nor there, because application of mind, it's the order of the court. Application of mind can be if the court has applied mind and deferred it and then ultimately decided it at a later stage. So just let me read 319. 319 is crystal clear. It was referred for interpretation, and Hardeep Singh is consistently followed by courts thereafter. There are judgments of this honorable court consistently following Hardeep Singh, and according to me, I am in no grey area. My case is completely covered by Hardeep Singh's view. But anyway, let me
before that, just tell us some basic facts in your case.
Yes.
Basic facts, then we will come to 319.
Let me just read 319 and then I'll go to the basic facts. Power, 319 says, power to proceed against other persons appearing to be guilty of offence, where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person should be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed. So the crucial words are, where in the course of any inquiry into or trial of an offence. That's the stage at which 319 can be used. Now, my lord, just kindly have one or two other sections, my lord. Just kindly see here itself, section 353.
What, 3?
53. .353 dealing with judgment.
Yes, we have.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of trial or at some subsequent time. So, when the matter is kept for judgment, it is after termination of trial and it can be pronounced immediately, or he can fix a date for pronouncement of judgment. But trial is over at that point of time. And what happens after judgment is pronounced is 362. Just this link will be complete. 362. The court will become functus officio. That is why your lordship says no review, no other application except clerical mistake, etc. Kindly have 362.
Yes.
Court not to alter judgment, save as provided by this court or any other law for the time being in force. No court, when it has signed its judgment or final order after disposing of the case, shall alter or review the same except to correct a clerical or arithmetical error. Your lordships have interpreted this to mean that after pronouncement, court is actually functus officio. I have made a note on that. I'll just be passing it over. Now, what is my case? But I have just made this pass on.
And even review is not permissible here.
In criminal law, yes. But I have just made, just if I
To a certain extent, 482 applicable.
yes. Just kindly see this list of dates. I'll tell your lordships in my own words.
Basic facts we should know.
Yes. I'm going to give your lordship the facts. And in fact, there is a huge, this one, I am also a politician. What has happened in this case, I'll give your lordships a broad overview and then I'll make out my case. I come from a political family in the state of Punjab. My father was an education minister in the earlier years. Of course, now he is no more. I actually contested elections for the last 2-3 decades. Earlier, I contested with the Congress. Then I became leader of opposition in the Aam Aadmi Party. When this whole episode happened, I was leader of opposition of the Aam Aadmi Party. I was exposing all these sand scams and other scams. This is my pleaded case. It's not something out of the pleadings. So I was exposing all these scams. Now what happens is that on 5th March 2015, and if your lordship will have page 1, I'll just quickly take your lordship through this list of dates, and then I just quickly, and then because depending on whether I had other arguments of mal of ID, etc. So if your lordship in this combination will examine only my first submission.
No, we are only considering the referred question.
All right.
Rest of all, I think it has to go back to
back. So then I will give your lordships broadly the factual basis and in the setting in which the case arises, and then go to the referred question straight away. So after giving your lordship broadly the setting in which the case is arising and what actually happened, so that your lordship has an overview. So my lord, on 5th of March 2015, an FIR is lodged under the NDPS Act and under the Arms Act, etc. A total of at police station Sadar Jalalabad, district Fazilka, against 11 accused persons for heroin trade. Now there are total of 8 persons are arrested, including one Gurdev Singh of Bholanath constituency, ex-Sarpanch. I contest elections from this constituency, my lord, Bholanath. Sarpanch and ex-chairman market committee. Alleged recoveries are made from them. the petitioner is not named in the FIR, nor any overt or covert act is attributed to the petitioner. A special investigation team is constituted on 9th March 2015 through the IG Bathinda zone to supervise the investigation in the present case. That SIT is headed by the DIG Firozpur, SSP Fazilka and SP Fazilka as its members. According to me, the sole purpose of this SIT is to dig out some way to connect me with this crime. Now, the SIT gathers some phone call records of Gurdev Singh with Joga Singh and Manish Kumar. Joga Singh is my private security PSO and Manish Kumar is my PA. They are petitioners in the second petition, which is also before your lordships. That is 503.1. Gurdev Singh belongs to the constituency of Sukhpal Singh Khera petitioner. On 10th March 2015, various news items appear in the media quoting the SIT members as saying that phone calls between the petitioner and Gurdev Singh and making derogatory remarks against the petitioner. Now on 4th May 2015, in view of the apprehension of being falsely implicated, Sukhpal Khera approaches the High Court by filing a criminal writ petition number 8999 of 2015. The prayer I have reproduced at page M on that petition. I said, transfer this investigation to CBI. Prayer 1. Prayer 2, I said, please protect me from arrest. Prayer 3, I said, in case I am to be arrested, give me 1 month's notice. And prayer 4 is another miscellaneous prayer that I had made. These were the 4 prayers. Now, my lord, what happens? On 6 September 2015, challan is filed against 9 persons, since 2 were declared proclaimed offenders and 1 of them was never apprehended. So the trial actually is against 11, but initial challan is only against 9 because 2 are declared proclaimed offenders. Now, thereafter, my lord, the investigating agency files an affidavit through the SSP Fazilka and writ petition number so-and-so, that is my writ petition. Now, this is very crucial, extremely crucial. On 6th July 2016, evidence of PW4, that is Ajmer Singh DSP and PW5 Jaspant Singh Inspector was completed and a request by the prosecution for recalling on the same day is declined by the trial. So these 2 persons, Ajmer Singh and Jaswant Singh, who will ultimately then come back by a 311 application, they tender their evidence. In their evidence, they talk about me, but they do not say I am in any way connected with the crime. If need be, I'll show that to your lordship.
What do you mean by talk about you?
They say that yes, a question is put to them by the accused that this whole thing is politically motivated, that the accused are connected with Sukhpal Khera, and therefore they are being implicated falsely due to their connection with Sukhpal Khera by the then Deputy Chief Minister, who is also named, my lord, in that examination and cross-examination. Both of them do not implicate me in the crime at all, and I will read it if need be. Then I'll just complete the things. In May, this evidence takes place, my lord, in July 2016. In May then after this, there is a first supplementary charge sheet against one of the 2 absconding accused. He's detained, and therefore there is a supplementary charge sheet against him. Then the trial proceeds. By 31st July 2017, evidence of almost all other witnesses is over. Then if your lordship will just have the very last page of this list of dates. Just this, what I've given, just kindly have the very last page. Page 26. Just see these dates, how the matter proceeds. So 6 September 2015, your lordship has that date or not? 6 September 2015 is the charge sheet against the 9 original persons. 18th October 2016 is the first supplementary charge sheet against that one of the absconding accused who is then caught. 28th May 2017 is the mining scam raised by me in the newspapers. One minister has to resign as a result of that. It becomes a huge scandal and a big issue in the state. In my rejoinder, I have placed those newspapers on the record. Now, my lord, it is then that on 20th July 2017, a second supplementary charge sheet is filed. The second supplementary charge sheet does not say anything, but is only filed for the purpose of placing on record some alleged call records of conversations between Gurdev Singh, his sister Charanjit Kaur, between, they say, me and my PS. That's the sole purpose of this second supplementary charge. After this second supplementary charge sheet is filed on 20th July, hot on heels, 31st July 2017, an application is filed for recalling of those two persons, PW4 and 5. The reason, those two police officers, the reason given in the application is their conversation with the accused and the call records have to be connected with the accused. That's the reason in the application for recall. Recall originally had been declined. I had read to your lordships. This recall application is allowed on 17th August 2017. On 14th September 2017, these two witnesses are re-examined. In their 2-3 pages of re-examination, they do not talk about any other accused. Their whole evidence is about linking me with the call records and Gurdev Singh. Now, that original statement turns curtain. And that's the whole purpose of their examination on this 14th September 2017. Then, my lord, on 21st September, they get one more person to say, I have got records from the telephone companies regarding those calls. He is asked to state that, have you got a 65B certificate? He says, I don't have a 65B certificate. In the evidence, in the written statement filed here, 2 undated 65B certificates are produced by the state, just pushed in. So I have an issue about that. Then, my lord, so after 14 September, 21st September, when this evidence, according to me, in commas, is procured against me through persons who had already testified and never blamed me, this application under 319 is filed on 21st September, and shortly it is allowed, and that is how I am made an accused in the trial. So one of my main...
What is the date on which the application is allowed?
Yes, the date on which the application is allowed is 31st October 2017.
What date? What date?
31st October 2017, the same day when the judgment is pronounced of conviction and sentence. So, my lord, according to him, Hardeep Singh also says what kind of evidence is required. And I had addressed at great length about the fact that, leave aside my first submission, this evidence is completely procured to fix me. And therefore, my lord, that is one of my main submissions. But in any case,
that is on the merits of the matter.
That's
We have to.
I just wanted to give your lordships a sort of a setting. And what do they say? How are they linking me? They say the same two officers who came. They say when these...
Particularly, again, we can't go into the merits of the matter.
But I'm just
We
giving
have
your
to
lordships.
examine as to whether.
In the next 5 minutes, I'm just going to give your lordship a little flavor of what I am facing. So that's all, and then I'll come to the questions. I have prepared some.
We are called upon to answer some question, and we have to limit ourselves to that.
All.
This is my submission, my lord. In fact, it is only a reference. So, my lords are contemplating about the reference only. As far as the merits are concerned, my lord, that will be seen by.
That is what I have said.
Grateful, so grateful, so grateful.
Yes.
Yes.
Yes, Mr. Patwalia.
Flavor, so that our appetite.
So I just before lunch, my lord, I say. So
Some food for thought.
So just 2 more lines and I finish this. 2 more, because not his whole life, it's a life-changing situation for him. He was the leader of the opposition. He had to resign. He had to quit. His family is one of the premier families in the state. It's smeared on the basis. Now, what happens interestingly more, on the basis of this FIR now, there is a PMLA against me.
Just trying to define the meaning of premier family.
I was just telling my brother,
It's beyond
my learned brother, in Punjab, premier family would mean family like Mr. Patwalia.
I'm grateful, my lord, but unfortunately, we are far away from politics, my lord. So, or fortunately, I should say. So, my lord, they are asked, what is the basis? They say, we actually interrogated them when they were arrested. So, what do you have to show? They show 5-6 loose pages of white paper. 5-6 loose pages. In cross, they are put Is this on the case diary format? They say no. Is this numbered? No. Did you produce it anywhere? No. So 7-8 loose white pages sheets of cross-examination are the basis of all. So, my lord, that is how, therefore, I am now, I then, after that, I went in revision before the High Court. High Court rejected it, ultimately saying that High Court basically said two things. High Court relied on Shrikant, but the reference order itself put Shrikant out of the picture by saying Shrikant was on a totally different factual situation, because in Shrikant, the order under 319 was made admittedly during the pendency of the trial. But because
Patwalia, if the trial court had allowed 319 application before the pronouncement of the judgment, perhaps you had no case according.
on my first point, yes.
No, merits, we are not examining
Yes,
facts.
yes, yes.
You had no problem. You had no problem.
I would not have been able to argue that that Hardeep Singh's is violated. Yes, your lordship is right.
All right. Now, judgment was pronounced on the same day this 319 application was allowed.
Correct.
Before the pronouncement of the judgment, if 319 is allowed and then judgment is pronounced, what objection do you have?
Well, then I could have had an objection, because once the judgment, the trial was over earlier. The trial had been concluded, matter was kept for judgment, and therefore, by virtue of 353, therefore the court could not have done it.
Well, with my lord's mention only one thing. Well, Hardeep Singh, which my friend is relying upon, says till pronouncement. I can read that. It is not conclusion of trial. Hardeep Singh says till pronouncement. So I'll refer to the paragraph. He's relying
I will
upon.
also read it, my lord. Let my friend not be very anxious.
No, I'm just saying the Hardeep Singh you are relying upon, that says till.
So therefore, your lordship put me a question. It says inquiry or trial. According to me,
His contention appears.
We want to ask. Now, judgment is pronounced. Thereafter, 319 application is allowed. In a given case. Now, that has to be separately numbered, is it? What is the procedure there?
so I'll tell your lordship what happened.
What happens there?
Well, in the present case, it was already
So,
separated.
same case can't continue. Same case can't continue.
Well, in the present case, it
We
was
are
already
before
separated.
constitution
It was already separated. In the present case, it was already separated. 319, Malad, the Honorable High Court ordered the stay of the proceedings in the other case. So the learned trial court separated this application from the main case. So it was already separated and segregated, bifurcated from the trial.
Worse. But I will answer your lordship's
No, why we are asking? There is
I am
some,
answering
there is
that
some
question.
purpose. Patwala, please listen to. You can answer it too.
Yeah, no difficulty.
Now, for example, supposing if an accused is absconding,
Correct.
trial can't stop. What happens?
I'll answer that. In this case, one accused is absconding.
What has happened?
Now, in this absconding,
Trial is separated.
no,
And
there
it
is
will
no-
be tried
there-
today separately.
No. In this case, one accused is absconding. On the date when my application was allowed, there was no trial pending regarding him because no charge sheet had been filed in his case. It was still at the stage of investigation. So therefore, that's crucial. It's a very pertinent question here. There were 9 accused to put on trial initially. 2 were absconding. One of the 2 was then arrested. For him, charge sheet was filed, first supplementary charge sheet. For the second absconding, on the date when my application was allowed, there was no charge sheet. There was no trial pending. So therefore, what the court had to do, when the court allows my application under 319, the court gives a further direction to the police to file a supplementary charge sheet against me. That direction, the High Court, while dismissing my revision, quashes that direction, saying such a direction could not have been given. So therefore,
Charge sheet cannot be filed against you, then how can?
Yes,
trial-
it cannot.
so there can be no direction to file a charge sheet, is the view taken by the High Court.
That would lead to an anomalous situation.
No, that's the correct position in law. High Court.
No. if the High Court has caused the direction to file a charge sheet,
Correct.
and also on the other hand, granted permission to conduct a trial against you. So can there be a trial without a charge sheet?
Yes, that's precisely the point. Therefore, this 319, Mr. Gai, please allow me to finish.
It is all right. I'm just putting my facts forth.
We will hear you, sir.
Oh, so great. So grateful. So
We will
great.
hear you, sir. We will-
I'm just putting the facts right. That is all.
We will hear
And
you.
I don't give any wrong.
No, I am
facts,
not
Mr. Gai.
saying that at all. I'm not saying, I'm adding to what you
And
said.
no intention
Mr.
of
Patwali,
starting
I'm just adding to your
Anyway,
facts.
Mr.
I can change my,
2 o'clock.
We have
Well, it is always better.
decorum here.
well, it is always better to argue before, not before an empty stomach, honorable judges.
It's, we have some decorum. So, my lord, therefore, the answer to your lordship's question. Therefore, it is even.
To learn decorum from Mr. Patwali.
Therefore, it is even more important that this 319 should be allowed when the trial is still pending. Because if you allow it after trial is concluded, you cannot give a mandate to the police to necessarily file a charge sheet. Therefore, it will reach a.
We consider it true.
Yes.
Yes, it becomes a tough case.
Take into Nagamuthu also. Supposing if you direct him to file a charge sheet itself without an investigation,
Absolutely.
is it permissible? You are presupposing, the judge presupposes that he is an accused.
So, therefore, my
That is
lord,
why-
It requires an investigation, if I am right, assuming it to be so under
let
170.
me answer your lordship.
Well, with respect, my lord.
Let me answer your lordship's question. Therefore, my lord,
Yes, sir.
319 necessarily has to be allowed when there is some trial pending. Because it cannot be allowed in a situation when there is no trial pending. In my case, on the date when my 319 was allowed, there was zero trial pending. I could have imagined if there was a trial pending against the absconding accused, still there would have been a trial pending. Therefore, my lord, the point is.
No, the trial insofar as a absconding accused is still pending in your case.
It's not, it was on that day not pending. Subsequently, I am told a charge sheet was filed in 2019 against that absconding accused. So in 2019, it is a fresh trial with a separate number of 2019. My application has been allowed in an earlier trial, which was not pending on that day. Therefore, the question was of filing a direction to file a supplementary charge sheet.
There would be a split up time.
All right, we will come back.
Yes, yes.
Very interesting question.
Correct, grateful.